State versus Charles. Mr. Charles is here. He is represented by Mr. App, and it's my understanding that this is a plea. Is that correct, Mr. App?
It is. It's a negotiated plea.
Okay.
How old are you, sir? How time to go to school?
I'm 39 years old, and I finished some college.
You're charged for 2 counts. Count 1, murder. Count 2, felony murder.
Yes.
And do you understand through negotiations with your defense counsel, both of those counts will be reduced to voluntary manslaughter under 16-5-2?
Yes.
Okay. How do you plead to these charges at number 23 SC 187925?
Guilty.
About Mr. Charles. He's 39, Judge. He's got some college. He's a full-time truck driver up in the state of New York. He's flown down here with permission of the court, which we appreciate, and appeared either virtually or in person at every court appearance. He has taken this case very seriously for many, many years that it's been pending. Don't have any qualms about denigrating the alleged victim in this case. He was known to rob people at gunpoint frequently and did so to Mr. Charles earlier in the day. As a result of that incident, Mr. Charles, who wasn't really familiar with guns or used guns, felt the need to arm himself and borrowed a firearm from a friend. Unfortunately, ran into Mr. Braswell again. And he's pleading guilty. We're not even asking for an Alford plea. I think had the case gone to trial, there would have been a pretty clear self-defense argument. But it's difficult when the state makes a probation offer on murder for us to say no, and we are, as a result, humbly, respectfully asking the court to accept that negotiated plea. He understands that he played some role in this and is pleading guilty to it. We are humble always before this honorable court and ask you to accept the negotiated recommendation.
Okay. Mr. Charles, you have a right to be heard. If there's anything you want to add, you don't have to add anything at all. But if there's anything you want to share with me, I'm happy to listen to it.
I'd like to apologize to the family of Mr. Braswell for my role in the whole situation.
Bro, imagine walking into court expecting a murder trial, and 5 seconds later they're talking about a negotiated plea. Wait, what? Then the defense starts painting this as self-defense, and suddenly this case isn't as simple as it looked. Chuckle the judge just sits there, calm as ever, barely blinking, like he's heard every plot twist imaginable. But hold up, the family's about to speak, and everything is about to change.
And that's really it.
Okay.
Jeremy Dev has had a great impact on my life. Before he died, before that man murdered him, I was a Jehovah's Witness for 20-something years. I had a lovely life. I was happy. Now, after his death, I suffer from PSTD, post-traumatic stress syndrome. I'm very depressed. And I don't think it's fair that he even had the nerve to ask for probation when you've taken a life. He took my son's life. Okay, he could have broke his leg, broke his arm. No, he murdered someone. So the fact that he has the opportunity to see his kids when I can't see mine, he has the opportunity to be free while my son is laying in a box in my closet. I don't think it's fair, and I think if any one of those people in the court, if he had killed one of your children, you would know how I feel. He needs to pay. Even if it's a year or 2, he needs to be in prison at least 5 years. I have forgiven this man, but he don't need to be free. He needs to suffer like I have suffered for 9 years. If he had killed your son or anybody's son in there, you wouldn't want him to have probation. My son is worth more than probation. You get probation for shoplifting, probation for DUI, for murder. Has Atlanta gotten that bad that you can kill someone and get away with murder? The DA? The judge? Any of you guys? How dare you even insult my son's death by saying probation? And that's how I feel. It's ruined my life. I'm trying to get my life back together. It has ruined it, but to even offer him probation for a life. Shame on you. And that's all I have to say.
Ms. Braswell, thank you for sharing your sentiments. I appreciate it. And again, I understand how difficult this is, that you've had to wait this long, and this is not the outcome that you would have expected, given what happened to your son. But it's important that you be heard, and you have been heard, and I'm glad that you had that opportunity. Thank you.
Please give him something. Give him a year of jail. Something. Something. How you gonna kill somebody and 9 years later want to get on probation? Where they do that at? Where? In Atlanta? No. Justice needs to be, Jeremy deserves some kind of justice. This man should get 5, at least, I don't care, 2 years, 3 years. If it was up to me, he would get life because he took a life. That's how it's supposed to be. You take a life, you murder someone, they take your life. But this is not my decision. I don't want him to get away with it. Please do something. If it's 2 years, get it. He needs to suffer. Please.
Nah, this courtroom got real quiet. The victim's mother isn't reading a statement. She's unloading 9 years of pain. Every sentence lands harder than the last. Then she calls probation an insult to her son's life. Phew. The judge's face stays composed, but you can see him listening with that serious, tight expression. Sai, you can feel the weight in the room, but now it's his turn to respond. What's he possibly going to say after that?
All right, Ms. Braswell, thank you.
Thank you.
The raw emotion of what she and her family has been going through over the last 9 years, what the state's review of the evidence led them to conclude, which is that this was a shooting in self-defense after Mr. Braswell had robbed Mr. Charles at gunpoint earlier in the same day. So we have a scenario that, as the state explained, there would be evidence that Mr. Braswell pointed a gun at Mr. Charles, took his property, and then later in the same day, the two encountered each other, and Mr. Braswell appeared to be reaching for something, and Mr. Charles, instead of waiting to have a gun pulled on him again, produced a gun and fired twice. Not 10 times, but twice, and then fled the scene. I think the defense had the possibility of getting a justification verdict at trial where a jury would conclude that Mr. Charles was defending himself when he did what he did, which would be a not guilty verdict, and there would be a finding of zero responsibility on Mr. Charles's behalf. But instead, Mr. Charles is coming in here accepting responsibility for having taken Mr. Braswell's life. Mr. Charles going to prison for a while doesn't bring Mr. Braswell back. Mr. Charles going to prison for a while doesn't make it less of a potential self-defense case. And the last thing I'll observe is that it's the state that has the ability, and not the court or the defense, to downgrade the murder charge and the felony murder charge in the indictment to voluntary manslaughter. That is a power they use sparingly, and in my experience, only when the facts and circumstances justify that. And so it is not my role to second guess their decision to allow Mr. Charles to plead to a lesser included.
Wait, the judge starts laying out the timeline, and suddenly the whole picture flips. Earlier robbery, possible self-defense, only 2 shots fired. I mean, this isn't the version most people expected. He's calmly breaking down every legal angle while barely changing expression, almost like he's teaching a class instead of deciding someone's future. But don't relax yet. He's building toward one decision, and everybody's waiting for it.
It sounds like it's factually supported, and it's certainly legally authorized for the state to allow a defendant to plead to a lesser included. They've exercised that authority. It's now my turn to determine what a reasonable sentence is, given the facts and circumstances that have been shared with me. Instead of there being absolute self-defense, which would require a verdict of not guilty, the jury could conclude that you were angry and so you pulled out the gun when you could have run. But of course, in Georgia, there's no duty to retreat. And Mr. App would have been arguing that very vigorously to the jury, that you didn't need to do anything other than protect yourself in that situation. And his argument would be that's what you did. And in Georgia, maybe the law of justification would cover that, but it might not. And a jury could have found you guilty of voluntary manslaughter, where in the heat of passion, as you're reliving what had happened to you just hours before when a gun was put in your face and your property was taken, you said, "This isn't going to happen again." And you did what you did. So I think there's a basis for the plea.
Listen to this. The judge basically says a jury could have seen this in completely different ways. Self-defense? Maybe. Heat of passion? Maybe. That's the kind of courtroom gamble nobody wants to make. He leans forward slightly, looking straight at the defendant with that unreadable expression. And then comes the pause. Count one. Wait. Don't blink now because the next words decide everything.
Count one, I'm going to sentence you to 10 years to serve, well, I'm sentencing you to 20 years to serve 3 months. The next 9 years and 9 months are on probation. And then the following 10 years are suspended. You will get credit for the 98 days you've already served. So it's a total sentence of 20 years to serve. You're not going into custody. He's just getting someone back there. It's 20 years to serve 3 months. The next 9 years and 9 months are on probation. So that's the 10. And the final 10 years are suspended. I have found that it is not a good use of the limited supervisor resources in Georgia or any other state to have someone on probation for 20 years. Your sentence is 20 years long, and I'm going to set some conditions of your suspended sentence so that if you mess up, and I don't think you will, but if you get arrested for something next year, in 5 years, in 15 years, that suspended sentence I can still revoke. But it does mean that that period of supervision would be at most 9 years and 9 months. So at the 10-year mark, probation ends, but you still are under sentence. So it's a 20-year sentence. Just the first 10 are under supervision. The first 3 months were under the supervision of the sheriff of Fulton County. You've served those 3 months. You get credit for those 3 months. You actually did 8 days beyond that. Upon your relocation to New York, you may not return to Georgia. It's a similar sentence to what Mr. App negotiated on your behalf. It's arguably slightly less severe because those final 10 years, you're not on supervision. Mr. Charles, anything else?
And there it is, not prison for decades like some expected, but a sentence with probation, suspended time, and strict conditions. Bro really walked in facing murder, and walked out with a deal that still changes the next 20 years of his life. The judge stays steady, explaining every condition without raising his voice, almost like the case ended long before the sentence was spoken. Chuckle justice or compromise, you decide. If you enjoy courtroom breakdowns with the twists nobody sees coming, hit like, subscribe to Case File USA, and I'll see you in the next case.